USCIS is getting sued over the increase in fees that applicants pay for things like green cards. Hi, my name is Oscar and I'm not a lawyer. In this channel, we talk about green cards like EB2 NIW or EB1A in which you can self-petition. And this means that you don't need to have a company sponsoring you, a job offer, and you can also do it without a lawyer, saving quite a bit of money. So let's talk about USCIS today. That's the agency that governs this kind of employment-based green cards. And we're going to see about this lawsuit that has emerged. As we knew, and I have a video on that, USCIS is going to increase fees across the board for pretty much all applicants. All processes are going to be affected. And in that video that you have here, you can see all the details about that rule that would take into effect April 1st, 2024. So we are just a few days away. In 2020, the agency tried a similar increase and they got sued, and the court ordered to suspend that increase. So actually, now it's been, I think, since 2016 that we didn't have a fee increase. That's one of the reasons that USCIS gave us to justify that they need to increase the fees, because it's been so long since they did it last. And the reason for that is, again, because they got sued. And this is especially important and relevant to this story that I'm going to tell you today. A new lawsuit has emerged, and we're going to see who is doing that, why they are doing that, and what can be the outcome for you, for the applicant, especially as we are so close to April 1st, 2024, when the new fees should take effect. Forbes broke the news yesterday, and I'll leave a link in the comment section below so you can, not the comment section, in the description section below, so you can actually go and read the news. They digest the lawsuit that you can also have access to. I'll leave the link to it, and you have it also in the Forbes news. And I went through the document, I went through the lawsuit, and in this video, I'm going to give you the things that I consider more interesting for us. So it's not a comprehensive review. I don't plan to tell you all about the lawsuit because it's a long document, but at least you should come out with some idea of what this lawsuit is about. So who are the main characters of this story? On one hand, we have the plaintiffs, the people that put together the lawsuit, and those are, on one hand, we have Samantha Moody, citizen of Canada, and EB5 investor. This is important because EB5 is one of those categories where the fees increase the most. So this person is saying, this is unfair, and we're going to see why. The American Immigrant Investor Alliance is a nonprofit that advocates for EB5 investors like Samantha Moody. And IT Service Alliance is a group for small and medium-sized tech companies in the IT sector, pretty much. On the other hand, we have the defendants, Alejandro Mayorkas, Secretary of U.S. Department of Homeland Security, and Ur Jadoo, Director of our famous USCIS agency. So we're going to see what are the reasons behind this lawsuit. One of the main reasons, and I knew this was going to be a problem for USCIS, is USCIS has established a new fee called the Asylum Program Fee. This affects all employers filing an I-140 or an I-129. An I-140 is the first step in a green card process, in an employment-based green card process. So you should all be familiar with that because it's the first step for an EB2 NIW or EB1A green card. And what USCIS is telling is, on top of the I-140 fee, which is $700 now and would be $715 with the increase in fees, we're going to give these employers an additional fee, $600 per petition filed, reduced to $300 for small companies, 25 employees or less, and $0 for nonprofits. This fee, according to USCIS, will fund the asylum programs. So USCIS is saying, well, we need money for the asylum initiatives that we do. Congress is not giving us the money, so we're going to take it from petitioners. But instead of saying we're going to take it from everyone, like they used to say in the past, now they are picking on a particular group of petition filers. and those are employers. I knew this would become a problem for USCIS because they are telling employers, on top of your fees for the petitions you want to file with us, we are going to charge you for something else that is not related to your petition, is not related to the worker you want to bring legally to the US, is something else. And by the way, asylum is also a legal process, it's not illegal, but that should be funded, in my opinion, either by everyone in the system, not by a portion of them, or by Congress directly, right? That would make a lot of sense. In fact, that Congress would fund that kind of work and not employers. And so what the lawsuit says is the proposed rule failed to consider why a paradigm shift from everyone pays to the transfer funding fee to employment-based applicants. So they are transferring that asylum fee from everyone to just a few. Now, a side note not included in this lawsuit is I've been asked what is going to happen with the asylum program fee for EB2 NIW or EB1A applicants. My opinion is that because those applicants are individuals and they are not employers, they should be exempt from paying. So if I would be filing in April 1st my petition, I would not submit the asylum program fee as an EB2 NIW or EB1A petitioner. But this is not clear. It's not clear because they haven't really specified that. I'm just saying it because the rule talks about employers. They talk about employers, they don't talk about self-petition individuals. We're going to have to wait and see what USCIS ends up doing. All right, more things that these plaintiffs claim. The EB5 increase is really high. For example, one of the forms they use in that process is the I-829, and it goes from $3,700, already pretty high, to $9,500. Some of the forms involved in this process go up by more than 200%. The lawsuit argues that previous increases did not lead to shorter timelines. And this is important. USCIS was saying, well, we need to increase fees because we want to improve the productivity of the process. But the lawsuit, in many instances, in many places, they argue that is not the case. That didn't happen in the past. When they increased fees, things didn't get better. And they actually call this former ombudsman, Prakash Khatri, who back in the day, in 2006, already warned Congress that because of this requirement that USCIS is self-funded, the agency often makes decisions that compromise operational efficiency to ensure revenue flow. And in other parts of the document, the plaintiffs also say that USCIS themselves have recently said that they are operating on a surplus. So they have money, I was going to say they have a lot of money. I don't know if it's a lot or a little, but they definitely already passed that situation post-COVID where they were in a bad shape financially. And now they claim that they are doing very, very well. So the people here in this lawsuit are saying, well, if you are doing so well, why do you have to increase my fees from $3,750 to $9,525? That sounds a little bit too much. Also, H-1B, a very important program for workers, the fees, this association is saying that they put IT consulting companies in crisis. On top of the fee increases for petitions, for the I-129, H-1B filing petition, and premium processing, which we know also went up recently, and I have a video about that as well. Companies will also need to pay for that famous asylum program fee. And here they are saying, using the current fees, fees for immigration, an employer in 2023 would have paid $11,840 to $17,760 per employee over the course of the 3-year visa. However, under this final rule, the new rule, an employer will likely see regulatory fees rise to $16,000 to $25,000 per employee. So you can see the severity of this measure for especially small and medium companies, but for companies across the board, they're going to pay a lot more to keep those H-1B workers working for them. And those workers are oftentimes critical for their mission. The lawsuit also criticizes USCIS for not providing data that the agency claims to have used to take these decisions. In many places in the final rule, USCIS claims that they have looked at the data, they have seen the numbers, and that is the reason that they need to take this initiative. But the lawsuit says in many places that they have not provided the data. They talk about data, but they don't show the data. So it looks a little bit shady in some way, right? Particularly, they target the asylum program fee because, according to them, this fee is more of a toll or a tax on select groups to fund operations for asylum adjudications. And that's what I was talking about earlier. It looks like that to me as well. You know, they are imposing a particular asylum fee for just a group of people that is not even the whole group of people applying for visas or green cards, right? So what the lawsuit demands is that a judge declares the final rule unlawful and invalid, that they stay the implementation or enforcement of the final rule. And this means, this legal way of saying, the fee increase should be cancelled if the court decides so. And that would be pretty good news for a lot of people right now, because that would put a pause on this whole process, and USCIS would have to go back and restart the process, restart drafting all those measures, publicly showing what they plan to do again. And so the process would be delayed and a lot of people would not have to pay more. Now, I'm not saying that an increase in fees is not needed. I actually think in some areas they need to update it. It's been a lot of time where fees have been stagnant, but I'm sure they can do a better job than what they already have done with this final rule that a lot of people are very angry about, especially because we know that USCIS doesn't really improve with this kind of measures. Now, if you're serious about this type of green cards, EB1A or EB2 NIW, I have websites to help you with the processes. EB1greencard.info, EB2NIW.info. I have a lot of posts, sample petitions, and especially my online courses. Here I'm showing the EB2 NIW online course, the course curriculum with 9 or 10 modules. Each of the modules has different lectures in English and in Spanish, so you can learn each step of the process and how to craft your own petition, your own cover letter, your own recommendation letters, your own business or professional plan, so you can have the best petition that you can imagine with a fraction of the cost that other routes would cost you. Okay, so right now we also have monthly live sessions for EB2 NIW, so join, and once a month you get to meet me and ask me a few of your questions. Now, going back to the lawsuit, this has happened before. In 2020, there was a precedent of this. August 3rd, 2020, the final rule for the fee increase, the 2020 fee increase, was published. But little did they know that just a few days later, the Association of Immigration Lawyers of America sued USCIS. They sued the agency the same way that we are seeing now these other entities are suing USCIS. And a court actually in September, at the end of September, this court said that the fee rule needed to be halted, and actually that destroyed the final rule, because October 2nd, 2020, that's the date where the rule would have been into effect, and that never happened. So we never had that fee increase from 2020. This is especially important now that we are seeing another lawsuit happening. Now, I don't know what's going to happen with that. We'll have to wait and see. We are very close to April 1st. So again, we really need to follow this closely. And I'm going to be here to tell you all the news about that, of course. So what's next? We'll have to wait. We'll have to see what action this court takes. Will it take any urgent action? Will they wait and we'll know after April 1st? We don't know. Because April 1st is very close, it seems unlikely to me that something drastic will happen, but you never know. Courts sometimes will take an urgent decision. In terms of the asylum program fee, it is unclear how USCIS will interpret the final rule. My interpretation is clear. Individuals should not pay this asylum program fee. By the way, if the court doesn't cancel the whole thing before April 1st, after April 1st, we're going to have to see how USCIS takes these EB2 NIW or EB1A green card cases and see if they want to charge us for that fee or not. My take, EB2 NIW, EB1A should not pay the fee based on how the final rule is written, because if you go to that final rule, they talk about employers, not individuals. They don't talk about self-petitions. So I hope that's true. I hope you don't have to pay for the asylum program fee. And I really hope this lawsuit really goes well. And in a few days or weeks, we have the news that the whole fee thing is canceled and they have to start over. So we have a lot more time. And those adjustment of status that were going to be so much more expensive, they can breathe a little bit. So thank you so much for being here one more week. Thank you for your attention. Subscribe, like this video, share it with others, and I will see you next week. And until then, good luck in your green card journey.